Welcome to All Things Financial with Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. Today, we're very happy to have a guest with us, Colin Morgan from Julian Gray Associates. Welcome, Colin. I appreciate your coming.
Well, thank you very much for having me. I appreciate your time.
Sure. Can you tell the viewers a little bit about you and your firm and what you try to do and what types of clients you help?
Absolutely. So I work in traditional estate planning as well as elder care planning and disability planning. Our firm started, years and years ago, focusing completely on elder care law and all those issues that come up as we age. However, as we went on, we noticed that our skill sets were useful for a lot more people. So basically, anybody who is looking to plan for, ahead for disability style planning, somebody who has immediate medical need, or even somebody who wants high caliber estate planning, should come to our firm for those types of issues or those types of services.
Now, is this only for the wealthy?
Absolutely not. Our goal is to be accessible. We want to work with as many people as possible, and we hand tailor our plans and our products to fit people's needs. What's different from us than a lot of attorneys is you kind of hear those stories about people who get these huge hourly bills, and every time they call their lawyer, they get pinged for $50 or something like that. And we try to do as much as we can on flat rates. Okay, we try to make a determination, figure out how many hours we're going to have in the plan, how much analysis we need, and really try to be as efficient as possible for our clients.
Okay. Now, I run into a lot of clients who, in their later years, or even planning for retirement, there are early stages I see in planning and later stages, pertaining mainly to the fear of going into a nursing home or having all their assets be wiped out due to medical needs or nursing homes.
Absolutely.
So let's say in the early stages, that would be someone that has maybe they didn't even retire yet, or they're looking at retirement. And what type planning would you say for someone who's theoretically young and healthy, 50 or 60, 65 years old, thinking of retiring and not even retired? How would they utilize your services?
Absolutely.
And what should they be thinking about?
And that's a great question. And part of that leads to, why we've started to rebrand ourselves, and we don't call ourselves only elder law attorneys. Because when you hear the word elder law, first off, the funny thing I get from people is they go, well, you're way too young to be an elder attorney, right? And I go, well, okay, that's not what you're thinking. So, but for our younger clients, there's a lot we can do. Particularly with individuals, like you said, looking at retiring, maybe they're in their 50s or early 60s. These are baby boomers, and their largest assets are IRAs generally. Okay, this is a generation, the pension plan is basically gone for most of these folks.
Right.
And so what we're looking at is a big tax bomb for the next generation if we don't address the IRA properly. So right now the IRS is letting us use actual trusts to serve as beneficiaries of IRAs as opposed to those IRAs going outright in cash to the next generation, which triggers sometimes an enormous income tax event.
Right.
And that's really the biggest issue that we see a lot with those folks. Now, our other, estate planning tools that we use for our older clients, like asset protection trusts and those style of plans that we're looking at, Veterans Affairs benefits, and I suppose we'll talk about that in later stages. But those are also useful for those folks. But it all depends on, what style of planning they want to go into. And also, how far they want to go into planning. But the very first thing that I mention for most of these clients is the IRA trust. Now, also traditional estate planning documents like a last will and testament, a healthcare power of attorney, a financial power of attorney. You'd be surprised to see how many people don't have those or haven't updated them since their kids were really young. I'm a bit of a shoe salesman with holes in my shoes because my parents will still say that I have to go live with my uncle in Harrisburg if they pass away. So, this is one of the typical things that you see oftentimes. So we correct those and we update those. And that's really just kind of a gateway to a lot of our services.
So how does this work with the IRAs? What's going on with the baby boomers? What are some of the benefits? How does that work?
Absolutely. Okay, great question. So a lot of our baby boomer clients, they have been contributing to their IRAs their entire careers. So they haven't accessed them, they haven't used them, and if you ask most of them, they'd rather not even touch it.
Right.
Now, oftentimes, as you know, when you turn 70 and a half, you have to start taking your required minimum distributions.
Right.
If I took a poll of my clients and asked how many of them would rather just keep their money in their IRAs, almost 100% would say that. So what that means is that's your primary cornerstone asset for estate planning. That's what a lot of these folks want to make sure passes to the next generation. Okay. So there are two ways to pass an IRA. I'm speaking very broadly right now. One is an outright distribution, and the other is stretching the IRA to the next generation. So if you use an outright distribution, what you're doing is essentially writing a check to the next generation. You're saying, you get all the money outright right now. Now, that might seem like a great thing. Now, as you and I both know, this is tremendously dangerous from a tax perspective, right? Because say you have two children and you have $500,000 in IRA money, and you just pass that outright. Now they each have a $250,000 ordinary income tax event for that year. They can spread it out over a period of 5 years, but still, it's a big tax bomb. So we suggest that people stretch the IRA to the next generation. Now, this in and of itself seems like a great solution, but it's also not airtight. The next generation can say, well, I opt to just take this outright anyways, oftentimes. They can say, that's a good sentiment, and I don't care about the tax, give it to me.
I do see that.
Yeah. So sometimes people get in their own way, with this planning. So if you use a trust as a beneficiary, as opposed to an individual, the trust takes over and the trust controls. And this means that stretch is locked in. Now, the beneficiaries really don't have as much say as they did before. Now, that doesn't mean that this is restrictive. We can draft language into the trust that says anytime the beneficiary needs money for health, education, maintenance, or support, that's a very typical standard, they can get principal out of the trust. Any income that the assets make, that are held in trust, they can get that out as well.
Okay.
Now, so there's another benefit to that, not just the tax planning. There's also a lot of liability planning in that as well. Now, I know, all of our families that we work with are perfect. Nobody ever gets divorced.
Right.
Nobody ever gets into debt trouble. And nobody has that friend that wants to open the pizza shop and just needs $100,000 up front. He'll double the money. So the trust really protects you from that as well. So there's an ex-spouse can't raid the trust to take away your children's inheritance. Bankruptcy has has a lot of issues piercing these trusts. All that kind of stuff comes into play. So while we would never want these things to happen to our clients, we need to really plan for the worst and hope for the best. That's something a client told me, I was going through this planning. I thought that was a great adage. So, again, plan for the worst and hope for the best. That's what this trust allows you to do.
Okay, that's interesting. I didn't know that was really available inside the IRAs frequently. Without ruining the stretch provision, and I guess that changed a couple of years ago or got clarified.
It did get clarified a few years ago, and it's something that we don't know how long it's going to be there because it's a pretty darn good planning tool. Mm-hmm. But while it's there, we're going to use it. And it's something that a lot of firms don't do. A lot of law firms don't understand it. A lot of law firms don't enter into this planning. So this is going back to me saying that, it's not just elder care planning. It's not just helping people get into nursing homes and things like that. It's also helping families convey wealth to the next generation without, blowing up the entire estate.
Okay. What are some of the other general provisions somebody makes early when they don't have any imminent need at all, apparently for elder law planning? But it's just estate planning and things that everybody should be doing.
Absolutely. One great tool is a revocable living trust. If there's no health issue at this point, and you want to maintain autonomy over your resources, and you want to continue to contribute and use and put things in and take things out, use a revocable living trust. This doesn't, a lot of the trusts, and we'll talk about these ones, the asset protection trusts and things for older folks, they're very restrictive. Mm-hmm. A revocable living trust is a very open document. That means that you can control the language of the trust. You can be your own trustee. You can basically run the entire show. You can take anything back out anytime you wish. The advantages to using a revocable living trust are that it avoids probate. It has all the liability planning that I just talked about with the IRA trust, and it also is a capital gains friendly trust for highly appreciated resources, especially the family home. I see families who bought their house for X amount of dollars 40 years ago, and now the house is worth, significantly more. We want to make sure that we're not creating a tax landmine for our clients' children, moreover, when they receive these resources. So a revocable living trust allows for that. And to dig a little bit deeper on probate, because that's one of my first questions I ask clients, have you ever been through the probate process? And when a client goes, well, I did it for my mom or dad, I know I have the trust sale, because they never want to go through it again.
Is that right?
It's a tough situation to go through. To probate an estate, you have to go to the courthouse, you have to raise the estate, take out letters, you have to go advertise everything in the estate. We could go down to orphans court right now and see every open estate and see who's set to inherit what from who right now. It's a very public process, and it could be costly. Right now, courts are allowing for a 6% essentially fee from an attorney to administer an estate. So you see a lot of traditional estate planning attorneys. There's nothing wrong with this, but this is just the old way of doing things. You set up the will and you set up the powers, and you hope you outlive your client, because one day the paycheck's coming.
Okay.
So those plans are very inexpensive and they're very quick, and they just end up costing a tremendous amount of money in the future. It's a little penny safe, a little pound foolish.
6% sounds little,
Right.
But 6% on $1 million, $60,000.
Right.
That's a big number.
Absolutely. And a large issue is where, say, the family house is the only resource. How do you get that 6%? You have to sell the house, and maybe they didn't want to sell the house. Mm-hmm. So when you have illiquid assets, it presents a whole host of other problems when you're looking at probate. Trust administration is significantly less expensive. At most, it's half of that. Mm-hmm. And this is if it's a acrimonious situation where people are fighting and people are going to court. Normally, you can resolve these things through an hourly fee, and you just make sure that everything's done efficiently.
Okay.
So,
Colin, it sounds to me like your firm is situated to help young people come to you, be affordable to come to you for their early needs, and evolve all through their life as their needs change, with your firm being able to adapt all along the way?
Absolutely. I love to start with a client early. I'm seeing a lot of people my age coming in to get their basic wills and their powers and things done, and I'm happy to do that. It takes me an afternoon to do that, and it's an inexpensive plan. Moving forward, as they accumulate resources and they start to build up a wealth of assets, then we do more work. We do more intensive work. The way, when we talk about fees, one of the problems in the legal field is oftentimes attorneys are commoditized, and they do it to themselves. They go, well, if you come to me, it's going to cost X amount of dollars, and I'm going to give you these documents, and it's like a trade. Mm-hmm. I prefer, and my firm prefers, to work based on our expertise, on our analysis, and our knowledge. So our intellectual property is what we can do for you. It's not, well, we can run these documents for you and get you to sign them. So our idea is to show the value of what we can do. Our planning is focused on saving a client exponentially more money than they pay us.
Okay.
So that's how we've broken out of that commoditization of the legal field. So when a client comes to me, if I have a long-term relationship with that client, we've built over time everything that saves them a heck of a lot of money. The earlier I can work with a client, the better, no matter what the situation is.
Okay, that's good. Now, if they come to you early, means probably 25 to 40 years old, let's say, I would say, when they're forming families and buying houses, getting married, right?
Absolutely.
Okay. When they come to you, what are their general considerations that you like to share with them and would like to share with everyone listening on what they need to start thinking about now rather than later?
Sure, absolutely. So the biggest issues that a lot of our people in their 20s and 30s have is they just got married, they just had their kids, their first couple kids, and they realize all of a sudden I have all this responsibility. Mm-hmm. And what happens if I predecease, my wife or kids or husband or kids? Where are they going to be? We have a mortgage. I'm still paying off student debt. All these questions come up. So what do we do? So we work with the client to make sure they have the right fundamental estate planning documents in place. Now, those documents are last will and testaments, a healthcare power of attorney, a financial power of attorney. So those 3 documents make up really the foundation of what everybody should have.
Okay.
And those should be designed to do a couple things. It should be designed to make sure that the surviving spouse, receives anything that's in the deceased spouse's name. Mm-hmm. And furthermore, we want to make sure where if God forbid something happens to both parents, the kids are going to be taken care of. So we have to set up fiduciaries for those kids, who's going to watch them, from a personal perspective, and also financial fiduciaries. Okay. And those might not be the same people. The most loving, caring, maternal or paternal aunt or uncle might be the worst person with money, mm-hmm. and the person who's great with money might be kind of cold. Okay, so you never know what that situation is going to be. So you have to really interview the client, and you have to set up these documents so that they're going to work properly in that fashion. And that happens in both the will as well as the financial power of attorney. So to explain what these documents do, I think that's a good, because I say these things and people might not necessarily know from a definition standpoint what they do. A last will and testament is probably the most widely used estate planning tool in our industry. Basically, in the elevator story of a last will and testament is this document says who gets what, in what shares, and who makes sure it happens.
Okay.
So you set up your beneficiaries. Okay, so your spouse and your children or friends, family, whoever that may be, and you tailor that to say exactly and precisely what you want those individuals to get. Generally, everybody splits everything up equally. Mm-hmm. That's 98% of those clients, unless they want to give something to the church or to a charity, or they have that one buddy who always helped out that they want to give something to. Above and beyond that, you want to appoint an individual to make sure that all happens. And the way you do that is you set up what's called a personal representative. Now, you've probably heard the term executor or executrix before, and that's what a lot of people, commonly think that is. And it's the same role. It's just a synonymous. It's a bit more of a modern word, for that. So that's the individual who's appointed to make sure everything happens. Basically, that person's principal job to immediately pick up the phone and call a law firm to make sure it happens, right? Because when you hand mix these things, you can run into a lot of problems.
Okay.
After that, the healthcare power of attorney is a document that allows you to appoint somebody to step into your shoes and make healthcare decisions for you in the event that you can't communicate them or make them for yourself. So this is incapacity. And this is something a lot of people never think about because they think, well, that'll never happen to me. Yeah. And unfortunately, it happens more often than I'd like to report. So you want to make sure that you have the right people making the decisions when it comes to healthcare. And what we attach to a healthcare power of attorney is called a living will. A living will is probably, next to the last will and testament, is probably the second most widely used estate planning tool that I see. You might not have any of those other documents, but your doctor gave you a living will to sign, when you entered his or her office. What a living will does is it allows you to drive how you want your medical care to be handled in the event that you're in an end-stage medical condition.
Okay.
This means that you're terminally ill and that there's no reasonable hope of recovery. It's a very uncomfortable conversation to have with a client. However, it's a very important conversation to have with a client because from a peace of mind perspective, you want to make sure that you have these decisions made ahead of time. And more importantly, you want to make sure that there are people who are going to work the way you would want them to, appointed as your fiduciary. Lastly, the financial power of attorney. This is a document that allows you to appoint an individual to make financial decisions for you. Now, there are different types of financial powers of attorney, and depending on your age as well as your cognitive ability at that point, you probably want to have different financial powers of attorney. I actually teach a 3-hour course on these 3 documents at CCAC.
Really?
Yeah, so I could go for a while about this,
Wow.
but I can tell you the great thing to do, or the best thing you can do is consult with a professional on it. They'll hand tailor exactly what you want.
Okay. Now, what happens if people do not take you up on this or contact you and they're still without the will and these documents and something happens? What's the problem?
Well, the problem is, and that's a great question, one of 2 things happens. One, they go, wow, that attorney wanted to charge me a lot of money. And LegalZoom, it's $50 and I get all this stuff. And I tell people it's kind of like if you get a really deep cut, right? You can probably do your own stitches, but it's going to be a lot more pleasant if you use a professional to do it. It might cost you a little bit more. So if you run into issues with these documents, if they're not drafted properly, you could have a contested estate with a will that might be vague. You could also have, if you have no will, then you're basically lofting your estate up to the Commonwealth of Pennsylvania and saying, you make the decisions for me. Same thing with not having a financial power of attorney or healthcare power of attorney. Now, we have laws in place that are based off of decades and decades, if not hundreds of years, of jurisprudence and decision-making and things like that. But for my estate, I don't want Pennsylvania making my decisions.
Right.
I want to work within that framework, but I want to have my own, have control of my own destiny, as much as I can. So that's the big issue there.
Now, you say you're teaching in where is it?
At CCAC.
CCAC?
I teach attorneys and CPAs and financial planners about what I do.
Okay.
So, yeah.
Now, is it, we were talking, you're also still training and educating yourself also. Could you tell them a little bit about that and what the issues are that you have to deal with in striving forward?
Absolutely. That's a great question. So, one of the great things about my firm is that we absolutely, as a practice group, we're encouraged to be lifelong students. Our goal is to continue to grow and evolve, be creative, and pursue educational, and related pursuits to our field. And what you're alluding to is a certified elder law attorney certification. That was a bit redundant, but and a CELA, a certified elder law attorney, is recognized as being an absolute specialist in the field. Now you have to practice for a period of years in only elder law. You have to handle only elder law issues for that long. Okay. You have to basically fill out an entire framework. If these are all my cases. And you have to have X amount of cases for medical assistance, X amount of cases for special needs planning, all that stuff. And moreover, you have to take an exam. So, 8 years ago when I started, when I got out of law school, I had to take the bar exam, right? Yeah. This is about half of a bar exam to get this thing.
Really?
Yeah, so it takes a while. You have to practice for a while to get it, to build up the credentials to receive it, and a couple certified elder law attorneys have to vouch for you as well, okay? So it's a small community. So there's a networking component, there's an examination component, and there's a practice component. And so I just took the exam a couple of weeks ago, so we're, fingers crossed, hoping I'll just be reaching out for my credentials after that.
Good.
So,
I wish you luck on that.
Well,
Hopefully by the time this show airs, we have good news.
Yeah, exactly. Yeah. I'll have a couple extra letters after my name.
Yeah, good. We're out of time for today. I appreciate your coming. Would you
Absolutely.
come back on? I'd like to talk to everybody about some of these elder law planning strategies that you have, which we didn't get time to cover today with that.
Absolutely. I'd love to. Thank you so much.
All right. Colin Morgan from Julian Gray Associates, thank you so much for coming. We're out of time today. Thanks, everyone, for listening and watching another edition of All Things Financial. We'll be back again next week.
Thanks a lot.
Colin, can you help everyone listening and watching on how to get a hold of you?
Absolutely. So there are 3 great ways to get in touch with us. First off, you can visit our website. That's grayelderlaw.com. Secondly, you can email me directly. That's Colin, Colin, at grayelderlaw.com. Or you can give us a call at our front office. That's 412-458-6000. And what will happen at that point is you'll talk to our triage staff, who they're absolute experts. They know more than most people, more than a lot of attorneys about what we do. And they'll get a lot of good information for me, okay? So I can start to formulate a plan proposal, and we'll have you in for a no-risk consultation. That means that if you decide that, not go with us, or if I decide that you don't need our services, then it's not going to cost you anything. So we think that creates a really good open relationship, with the firm right off the bat. So basically those are 3 ways to get in touch, and if you need us, we're always around. So feel free to give a call or email. Thank you.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through Sage Point Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with Sage Point Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.